Welcome back to Advocate DO, guys. Today's topic is all about the Bengaluru Daycare case. A daycare facility is built on an ultimate pillar of trust. But what happens when the trust is violently shattered inside a corporate campus? The shocking child abuse case from Bengaluru Brookefield area, where toddlers were allegedly locked in dark bathrooms, forced into front-loading washing machine to scare them, and sprayed the toilet jets, has triggered national-wide outrage. But beyond the viral WhatsApp videos, a massive legal battle has begun. The HAL Police Station has filed an FIR against 5 caregivers, and Bengaluru Court has already remanded one of the main accused, Vijayalakshmi, to 14 days of judicial custody. Today, we look at this through a strict legal lens. What criminal charges do these nannies face? Can the corporate chain be held liable? And what are the law governing in India? Let's break down the exact criminal section invoked in the FIR filed by District Child Protection Unit. First is Section 75 of Juvenile Justice Care and Protection of Children Act 2015. This is the core child-centric charge. It penalizes anyone who has actual charge or control of the child and assaults, abandons, abuses, or willfully neglects them, because these children are toddlers, which are 2 to 3 years old. This section carries severe penalties, including rigorous imprisonment for up to 3 years, which can extend heavily if actual physical or mental illness is caused to child. Next comes Section 351 Clause 2 of Bharatiya Nyaya Sanhita 2023. This replaces the old IPC Section 506 for criminal intimidation. The viral audio clip catch caregiver threatening the toddlers to stay quiet and ensuring no sound comes out. This section specially targets the act of threatening injury to a person to force them to alter their behavior. In this case, silencing crying babies through terror. The National Commission for Protection of Child Rights and the State Child Right Body have taken suo motu cognizance, dispatching a fact-finding them to audit the site, ensuring that these charges are rigorously pursued. Next comes the corporate and third-party liability dilemma. The biggest debate trending online right now is who is ultimately responsible. The facility, Little Bird Daycare, was operating directly inside the Capgemini IT campus for the benefit of its working employees. Capgemini immediately shut down the facility and stated they are cooperating fully with the law. However, reports indicate the operations were outsourced to the third-party service provider. Legally, this introduces two major concepts: vicarious liability, the principal employee rule. Generally, an employee is liable for the wrongful act of its employee committed during the course of employment. The third party vendor faces direct civil and criminal accountability for negligent hiring, zero background check, and a complete failure of supervisory oversight. The next is principal employer rule. Even if a company outsources a service under various labor law in India, the principal employer retains a duty of care to ensure safe working conditions on its premises. If internal whistleblower previously raised red flag and were ignored or terminated, as current media investigation suggests the corporate management could face severe legal hit for institutional negligence. Next comes statutory failure and Maternity Benefit Act. Why does the workplace daycare exist in the first place? It's not just corporate work, it's a legal mandate. Under the Maternity Benefit Amendment Act 2017, every established in India employing 50 or more employees must provide a mandatory facility within a prescribed distance. However, India severely lacks a uniform, stringent national licensing act, especially regulating private and corporate daycare. While the Ministry of Women and Child Development released the National Minimum Guideline for setting up and running creches, these guidelines are often treated as mere recommendation rather than heavily enforced penal statutory laws. The Karnataka Labor Department is supposed to maintain records of daycare locations and compliances safety details. This case highlights a systematic regulatory failure in how frequently these private parameters are audited by state authorities. So let me conclude. This Bengaluru horror story isn't just an isolated case of cruel individuals. It's a wake up call for Indian corporate childcare regulatory framework. Legal accountability must stretch beyond the immediate caregivers to the agency that hired them and the system that fails to monitor them. What do you think? Should top corporate executives be legally penalized when outsourced facilities on this campus abuse children? Let me know your thoughts in the comments below. Don't forget to like, share this legal breakdown to spread awareness and subscribe for more deep dives. Thank you.